Dear students, welcome to the Indian Constitution virtual class. Today I am going to discuss about the right to constitutional remedies, which is one of the important fundamental right in our constitution. So its aim is to protect all other fundamental rights which are uh, guaranteed by the constitution. So let us discuss what are the details of right to constitutional remedies and what constitutional safeguards are provided for the people to protect their fundamental rights. Right to constitutional remedies, Article 32. The right to move to the court for securing the fundamental rights is enshrined in the Constitution. Article 32 provides effective provisions for the protection of fundamental rights. It guarantees the right to move to the Supreme Court by appropriate proceedings for the enforcement of the rights. It empowers the Supreme Court to issue directions or orders or writs for this purpose. So, first let us know what is writ. The general meaning of the term writ. So, it is a formal order in writing issued under seal in the name of a sovereign government, court, or other authority commanding an officer or other person to whom it is issued to do or refrain from doing some act specified therein. So, this is the general meaning of the term writ. The purpose of issuing writs. So, there are five types of writs. The first is habeas corpus. So, meaning of this word habeas corpus is you may have the body. The purpose to issue this writ is to release a person who has been detained unlawfully, whether in prison or in private custody. Second writ, mandamus. So its meaning is we command. The purpose to issue this writ is to secure the performance of public duties by lower court, tribunal, or public authority. Then, third writ, certiorari. So, its meaning is to be certified. The purpose to issue this writ is to quash the order already passed by an inferior court, tribunal, or quasi judicial authority. Fourth writ, prohibition. So, the purpose to issue this writ is to prohibit an inferior court from continuing the proceedings in a particular case where it has no jurisdiction to try. Fifth writ, quo warranto. The meaning of the word quo warranto is what is your authority. The purpose to issue this writ by the court is to restrain a person from holding a public office which he is not entitled. So let's go in detail. Writ of habeas corpus. So, as I said earlier, habeas corpus means you may have the body. A person, when arrested, can move the court for the issue of habeas corpus. So it is an order by a court to the detaining authority to produce the arrested person before it so that it may examine whether the person has been detained lawfully or otherwise. If the court is convinced that the person is illegally detained, it can issue orders for his release. So sometimes the people may apply for habeas corpus writ if any of their family members are detained by the police. So habeas corpus in common language means the arrested person should be produced before a magistrate court within 24 hours. So, if the police or concerned detaining authority fails to produce a person within 24 hours, the concerned family members can approach the court to issue the habeas corpus writ. So, if the arrest is unlawful, immediately the police should release the person who is arrested by them. So this protection we will get through habeas corpus writ. So writ of mandamus. Mandamus is a Latin word which means we command. Mandamus is an order from a superior, superior court to a lower court or tribunal or public authority to perform an act which falls within its duty. Simply, it is a writ issued to a public official to do a thing which is a part of his official duty, but which he has failed to do so far. This writ cannot be claimed as a matter of right. So it is the discretionary power of a court to issue such writs. Writ of Certiorari. Literally, certiorari means to be certified. The writ of certiorari is issued by the Supreme Court to some inferior court or tribunal to transfer the matter to it or to some other superior authority for proper consideration. Writ of prohibition. Writ of prohibition means to forbid or to stop, and it is particularly known as stay order. So, this writ is issued when a lower court or a body tries to transgress the limits or powers vested in it. It is a writ issued by a superior court to the lower court or a tribunal forbidding it to perform an act outside its jurisdiction. So, after the issue of this writ, proceedings in the lower court, etc., come to a stop. So, if the proceedings are started in a lower court, which has no jurisdiction over the case, so then the superior court can ask the lower court to stop the proceedings and to transfer the particular case to the superior court. Writ of quo warranto. The word quo warranto literally means on what authority one is holding the public office. It is a writ issued with a view to restraining a person from acting in a public office to which he is not entitled. For example, a person of 62 years has been appointed to fill a public office whereas the retirement age is 60 years. Now, the appropriate High Court has a right to issue a writ of quo warranto against the person and declare the office vacant. So, its simple meaning of this is the person who is above 60 years cannot be appointed freshly for any government office. Why? Because the retirement age in uh, in state or in India is 60 years. So above 60 years person cannot be appointed by the higher authorities. So this is an offense. So the public interest litigation can also be filed in a court against such kind of appointments. Then next go to right to property, which is earlier one of the fundamental rights, but now it is only uh, a common legal right in our constitution. This right is deleted from the list of fundamental rights by the 44th Amendment and made a legal right under Article 300 A. So earlier, when it was a fundamental right, so there was no rights to any public authority to acquire the property of uh, the people. Why? Because it was declared as a fundamental right. So, because of this 44th Amendment, so this right has been omitted and made only a legal right. So, Article 31 deals with right to property and other provisions. So, according to this right, the people have the uh, legal uh, rights to own, acquire, and administer the property according to their choice or according to their capacity. But whenever the property is required for public use, then the state can acquire such property of a person. But the state, while acquiring a public property, it should give the compensation to the property owner. So, this is what Article 31, 31A, and 31B says. Next, criticisms of fundamental rights. So, fundamental rights are fundamental. Uh, no court, no parliament has the right to go against the fundamental rights. But all fundamental rights are uh, criticized by the critics on various grounds. The fundamental rights are criticized by many constitutional experts. They point out several weaknesses of the Indian Bill of Rights. Their criticisms are as under: difficult language. So, the language used uh, in part 3 of the Constitution is a very difficult language where the common man cannot understand the uh, the terms which are used to explain fundamental rights. The Indian Constitution and its part 3 has been written in a difficult and technical language. It has made it a lawyer's paradise. So, this feature makes it difficult for a common citizen to understand the meaning and scope of his fundamental rights. Second criticism pointed out by the experts is excessive exceptions. The Constitution, while enumerating the rights, also provides for several exceptions and limitations in respect of each right. First, A particular right is described in near absolute terms and then a list of exceptions or limitations stands incorporated. So, in the name of reasonable restrictions, the Constitution has imposed several limitations on fundamental rights. So, what we can say in a common language, what is giving in a right hand, the government will take in the left hand. So, this means that the fundamental rights are guaranteed, many freedoms are guaranteed, but the government at the same time imposed many limitations and restrictions on the enjoyment of fundamental rights. There is no absolute freedom to enjoy our rights, which are granted by the Constitution. Therefore, the critics point out this is one of the criticisms of fundamental rights. Lack of social and economic rights. The Bill of Rights, Part 3, is also inadequate insofar as it fails to incorporate social and economic rights. So the concentration is given to many rights which are related to other issues, but the Part 3 fails to incorporate some social and economic rights under the list of fundamental rights. It gives no place to such rights as right to work, right to rest, right to leisure, right to old age security, and other such socio-economic rights. So, the information about these rights is not clearly mentioned under the fundamental rights. Deletion of right to property is another criticism of fundamental rights. By 44th Amendment of the Constitution, the right to property was deleted as a fundamental right. So it was made a legal right under Article 300A. The deletion of right to property has limited further the scope of Part 3 of the Constitution. Then another criticism, Parliament can amend fundamental rights. So sometimes the Parliament can also make some modifications to the fundamental rights. The Constitution has placed in the hands of the Parliament the power to amend fundamental rights. This power of the Parliament was given constitutional status by the 25th Amendment, which amend Articles 13 and Article 368 for this purpose. The Supreme Court, while accepting this power of the Parliament, has held that the Parliament cannot use this power to change the basic structure of the Constitution, and this Part 3 is a part of the basic structure of the Constitution. No recognition of natural rights. The Constitution specifies that there is no right outside the rights mentioned in Part 3. So it gives no place to natural rights of a man like rights based upon such sacred principle as natural justice. Many natural rights are uh, guaranteed to the people, but no information is given under the fundamental rights clearly. So, this is another uh, criticism of fundamental rights. Next, go to the fundamental duties. First, let us know what fundamental duties are. Originally 10 in number, the fundamental duties were increased to 11 by the 86th Amendment in 2002. These duties were meant to bring our Constitution in line with the Universal Declaration of Human Rights and the constitutions of Japan, China, and USSR. So it was adopted based on the recommendations of the Swaran Singh Committee. Importance of fundamental duties. Fundamental duties serve as a reminder to perform specific duties towards society and warning to citizens against antisocial activities. They serve as a warning against the anti national and antisocial activities like burning of national flag, destroying public property, and so on. They serve as a source of inspiration for the citizens and promote a sense of discipline and commitment among them.